Hello, ladies and gentlemen. Coming to you this evening. We're kind of wrapping up for the session. Just wanted to do the cumulative course review just to briefly talk about everything we talked about this semester, just to refresh before you go into the exam. I won't talk about what we did writing wise. I'll mention it, but I won't go very in depth on that because the exam itself does not involve writing. Even though at this point you do have another writing assignment, um, just do. But well, I'll briefly talk about it. I think, yeah, I'll go ahead and talk about it. So, course started out of course with class introduction and the writing workshop. Of course, in the writing workshop I talked about um legal writing or persuasive essay writing. So just not about legal writing, but also about just general persuasive essay writing. How persuasive essay writing is not the same as writing poetry or prose of some sort. Is actually highly technical and it's boring. So it doesn't. It's not the fun type of writing, but it's the writing, the type of writing that you use when you're trying to get a point across and teach people, kind of let people know why you think the way you think, why you have the opinion you have. So we talked about five paragraph theme writing, where you have a thesis statement or a point you're trying to make, and then under that point, you also have, in five paragraph theme is um, three reasons, but of course, you can be four paragraph or even less. But you don't have to have you don't have to have three reasons for every time you use the five paragraph theme. But the way we were taught, we had to have like three reasons. So of course, with your thesis paragraph and your three, breaking down three reasons, and then your conclusory paragraph, of course, is always five paragraphs. But really, what that that's just a highly structured means of writing where you're stating your point, you're giving reasons that support your point, talking about each reason in the paragraphing, and then you're concluding by stating pretty much the thesis statement again of what your point was and why, just very briefly in the closing paragraph. So that's the structure of five paragraph themed writing. I also told you about IRAC and CRAC, which is the type of writing that we use is kind of the cousin of five paragraph thing writing, but it's a tad bit different. It's highly structured, just like five paragraph theme writing. It opens up with you making a point or stating an issue. And then, of course, there are paragraphs that you use. The paragraphs are different, have different acronyms, but uh, the paragraphs you use in between that thesis or that point or the issue that you're exposing, um, and the final paragraph, which is the conclusory paragraph. Those paragraphs in the middle are the paragraphs that you use to explain your point or why you're going to conclude or contend the way you contend. So it's a tad bit different. With IRAC and CRAC, you either start with the issue statement in your first paragraph where you state what the issue is. In other words, what are we trying to figure out? So the issue is whether, and it's WHETHER. The issue is whether blah 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 blah. And then you state your issue at some point in that first paragraph. Of course, when I'm grading, I'm looking for it in the first two or three sentences, so I know what we're talking about. Then your next paragraph or your next breakdown is going to be the rule statement. So, in other words, what's the body of law or the rationale we're going to apply to answer the hypothetical question? And then from there, once we state the rationale and the law we're going to apply, then we do the analysis portion. And the analysis portion is when we mention facts from the hypothetical that help us prove our point, and then we apply it to the rule. So we say, well, the rule states this, and then the facts, this happened, this happened, this happened, and that goes along with the definition of whatever the rule of law we're applying. So that's what you do in the analysis portion, and then at the end you conclude by saying, in conclusion, and you state your contention again. Um, that's with issue based writing. Contention based writing is the same, except instead of stating an issue or stating kind of what we're talking about or what the question is we're trying to answer, you actually give the answer. You give a contention. So you said at the beginning. So um, this person is guilty of first degree murder, and then from there, what is the definition of first degree murder? Then under that, the analysis, you talk about the facts that were given in the hypothetical, um, that satisfy the elements of first degree murder. And then in conclusion, you say in the next paragraph, in conclusion, because this happened, all the elements for first degree murder were met by these facts. Um, the defendant is guilty of first degree murder. So that's the structure in legal writing. So that was the legal writing workshop. Just ran over briefly again. Of course, that workshop is still actually posted. It's not timed out. So if you want to look at it again before you do the next writing assignment, you feel free. I would advise you do that. So from there, we dove into the book. We went chapter by chapter. Chapter one, we just talked about the introduction to criminal procedure, what criminal procedure is versus substantive criminal law, like law being the code or the rules that define what we can and can't do in society, or that contract between us as individuals and the other citizens around us, like that contract or that responsibility we have as citizens to each other. So we have a code of laws and things that we can and cannot do. So when we break those laws, or we're accused of breaking those laws, we're brought to court to answer as to either why we did, whether or not we did it, or if we did, why we did it, and maybe why we're justified. That's criminal law. Criminal procedure involves the procedure. So once you are accused of breaking a law or violating that code, um, what is the procedure? How are you brought before the court? As a matter of fact, before you even brought before the court, what are the rules that apply to law enforcement when they're investigating whether or not a law was broken, or if the law was broken, whether or not you're the one that broke the law? So that there are rules that apply to how um, law enforcement is supposed to investigate. So that the rules that apply to that, then there are rules that apply to what happens once you get arrested, or you're questioned, you're interrogated, uh, or you're searched, or your property searched. We talk about Fourth Amendment, all that stuff. I think I explained it to explain it in a nutshell. In a nutshell, criminal procedure is like the way the machine works or the system works, and what rights and rules apply to each stage in the process, or in the machine. Uh, then we talked about sources of criminal procedure. Number one source, of course, the United States Constitution. From there, we talked about case law, and usually we talked about the role of the courts in interpreting uh, constitutional law and statutory law. So sometimes things need to be explained, and that's why I talked about the Constitution being a living, breathing document, because the courts keep the Constitution alive. So as times change, of course, the Constitution, even though it's written and it remains the same as written unless it's amended, um, the Constitution is changed not necessarily by changing the words in the Constitution, but the interpretation of the Constitution is changed because the courts can adjust for the times. So, of course, like I said during the lecture, I think I did. Um, when the First Amendment was written, and when the Constitution was written in general, um, it was 1700s. They didn't have computers. They didn't have blogs. So the First Amendment essentially applied to like what you can say out of your mouth, and um, what else? What the newspaper could say and stuff like that. Because back then you actually had a paper, but now times have changed. So court rulings have had to include um, everything else that comes under the penumbra of First Amendment. That's the role of the court. So we'll talk about sources of law, sources of criminal procedural law. Also, from there, we jump to chapter three. That was chapter two. We jump to chapter three with searches and seizures, where we talked about the Fourth Amendment requirement that a search and a seizure be reasonable and based upon and there must be a warrant first obtained based upon probable cause before a person can be searched or seized. And then we talked about some of the exceptions to that warrant requirement. So that there's always going to be now the reasonable what do you call it? Probable cause. And of course, now what I say, the warrant has to be based upon probable cause. So that standard never changes. So even in situations where a warrant may not be required because it falls under the warrant list, the warrant reception, exception. I'm sorry. There's still, the one thing that never changes about searches and seizures, whether a warrant is required in a certain situation or not, or falls into an exception, the one thing that never changes is the fact that probable cause is the standard for searching and seizing. Um, so that never changes. The only thing that changes is whether or not the warrant is going to be a law enforcement officer is going to be required to go get a warrant before they search or seize someone or something. So that changes based upon the circumstances. Plain view doctrine, that's an exception. Um, what else? Plain view exigent circumstances and different other different exceptions. So we talked about those in chapter 3. Chapter 4, we talked about stop and frisk, the Terry case, where this is because where the court allowed law enforcement officers in this case to now confront people, not necessarily search and seize them, so it's not as deep as of an intrusion into their reasonable expectation of privacy. But it's just to stop, to talk to them, pat them down, just to make sure. For the law enforcement officer's safety, and question them briefly, brief questioning. But of course, it's limited in scope when it comes to time, and of course, you can't move the person. So it's not a stop and frisk when you take them into custody. So a stop and frisk is, hey, did you see what happened here tonight? What's your name? Can we see your ID? Stuff like that. But because it's not an intrusion into the pockets or into the personal space of a person, other than to pat them down to make sure that the law enforcement officer is safe, there was a lower standard that was applied. So probable cause wasn't needed, but reasonable suspicion replaced probable cause as the standard. Um, and Terry stop, so what we call stop and frisk. And there was a lower standard, so it's below probable cause. So the definition of probable cause, like I said, is fluid. It changes. No one has a perfect definition for it. And then even the lesser standard uh, of reasonable suspicion, there's not really any real definition. It's fluid as well, but we know it's less than probable cause. So, chapter 5, we talked about probable cause and arrest, and just the same thing. The warrant requirement for arrest, and and exceptions to that warrant requirement, but probable cause be always remaining probable cause and always being required. Um, we talked about chapter 6, searches and seizures of property. We talked about chapter 7. We talked about inspections and regulatory searches, and we talked about the lower standards for like searches in the airport, searches in the highly regulated industries like the food industry, or even um, highly regulated environmental regulations that are applied to businesses or factories where inspectors can come in and make sure they're up to code. There were differing standards there that were below um, probable cause as well. And sometimes, of course, in a lot of these situations, there was no warrant required. No warrant required. um, then we moved on to chapter 8, interrogations and confessions. Of course, I highlighted the exonerated 5 case where we talked about how they were in custody, they were interrogated, and we talked about the how confessions are often inaccurate in certain situations, especially when they're coerced. When they're not coerced, or where there's not any type of undue influence applied to a person, whether it be physical or psychological, then only then can is the statement, or what we call the confession, going to be reliable, because we know it's given based upon what happened, what they're saying happened. They're giving it voluntarily and knowingly, as opposed to having a fist in their face or being threatened or being toyed with psychologically. Um, Talked about that. We talked about, of course, the Miranda warning in that situation where they don't have to read you the Miranda warning just because you're being arrested. And we talked about how it only applies when you're in custody and being questioned. So two things: you're in custody and you're being questioned or interrogated. So and of course, when we talk about interrogation, it's a formal line of questioning by officers who are holding themselves out to be officers. So, of course, you're not protected for blabbering out to an undercover agent or agent that is, essentially a snitch or an informant who you just volunteer information to in the jail because you're bragging. Even if that person says, "Hey, what are you in for?" Yes, that's a question, but it doesn't count as an interrogation. So interrogation is essentially when law enforcement hold themselves out to be law enforcement and they ask you formal questions. And not just who you are and your ID, but asking you, formal, relevant questions to guilt or innocence in the case, or what happened in the case. So that's a interrogation as opposed to you being set up and talking to someone that has a wire, or an officer who's undercover that you're talking to. So that there's a difference. You're not protected in those situations, and they don't have to read you your Miranda warnings when you're kind of being set up, with uh, lack of a better word, what's the word? With an informant or an undercover. So you're not protected in those situations because you're essentially volunteering the information. Um, so let me see. Then we moved on. Of course, the midterms already been done, but then we moved on to chapter 9, which is eyewitness and scientific identification. Where we talked about eyewitness identification being one of the number one causes and leading causes of wrongful convictions. They're probably top number one, and a close second would be illegally obtained or confessions that are given as a result of coercion. So, but I would say the number one cause of convictions would be misidentification or eyewitness identification. Number two is when people are forced to confess because they're being coerced. So I would put those one. I put those one in both one and two respectively. Um, we talked about eyewitness identification and scientific identification. We talked about forensics, um, things that link a person to a crime scene, like a fingerprint. How yes, they're deemed to be reliable, but none of these things are perfect. DNA is the most reliable, um, but it's not perfect because we have to question how the DNA evidence was lifted, whether or not the sample's contaminated, even chain of custody, things of that nature. Um, that was eyewitness and scientific identification from chapter 9. Then chapter 10, the exclusionary rule and entrapment. So we talked about what happens, what's your remedy when your rights are violated and they obtain evidence after violating your rights, or as a part of violating your rights, they obtain evidence. What is your remedy? Of course, the first remedy is to have the evidence excluded and not be able to be used against you. So we talked about that. Then we talked about entrapment being when you're minding your business, and the government or the state, through law enforcement, coerces you into committing a crime that you weren't going to commit. Like, oh, hold this, these are dope, and these are drugs. And you're like, okay, and you hold it, and then that same person turns around and puts cuffs on you and says, now you're under arrest for possessing dope. It's like, bro, I was chilling. And you said hold this weed. So you created the crime, or you as a state agent, you put me in a situation. Not even put me in a situation. You created, or you made me commit the crime. So of course that is an affirmative defense. So we talked about that in chapter 10. Then chapter 11, civil and criminal remedies to constitutional violations. So we talked before about how um, you can always use the exclusionary rule to keep evidence out against you immediately. That kind of saves you in your own trial. But then outside of that, what are other remedies? Like, your rights were violated, you lost something, you lost time, you were beat up, you were roughed up, there's something that happened that violated your rights. What else can you do outside of just excluding the evidence and getting the case dismissed? You can file lawsuits in certain situations if the cop does something illegal. Um, and violating your rights, sometimes that law enforcement officer can be charged. So we talked about stuff like that, citizens review boards and stuff of that nature. Um, and also internal affairs. Then we moved to chapter 12, where we talked about the initiation of legal process. We talked about what bail/bond it means. Um, We also talked kind of brushed over the fact the problem or the crisis with cash bail. I think I mentioned the fact that sometimes people can't afford bail. They sit in jail and they end up pleading guilty, not because they did something, not because they weren't justified in committing an act, but because they don't want to sit in jail. So it becomes kind of akin to a hostage situation, where now I'm sitting here in jail as a hostage, and I don't want to be held hostage anymore. So I'm just going to take a deal or do whatever they want me to do, so I'll get out. And it kind of happens in the cash bail system because everyone's not walking around prepared to pay a bail or a bond. The average person isn't. Now, the rich people that got it like that, but I don't. I don't know about you. Um, so we talked about that and the initiation of the criminal process and the right to counsel at these initial or at the initiation of legal process. Then we moved to chapter 13, where we talked about the courtroom, pre-trial and trial process, pre-trial motions. We talked about motions to suppress, stuff like that. And then we talked about actually starting the trial, the jury being the panel to pick through voir dire. And that's the line of questioning. You ask juries, and you panel them, and the people, and each side has a limited number of preemptory strikes and an unlimited number of strikes for cause. Talked about that and how after both sides go and take people off that they want on the jury, once all the dust clears, you end up with a fully impaneled jury, and that jury is now in place. Now we start the trial. Opening statements. After opening statements from both parties, then the state or the prosecution, who has to go first because they have the burden of production of evidence and they have the burden of proof. They have to present their case in chief. They put their witnesses on the stand. They direct examine them, and then each witness is actually then cross examined, or there's the opportunity to cross examine each witness. Then from there, we talked about also that in evidence, of course, evidence can only get in by being testified to. We don't just walk physical evidence into court. We also talked about the fact that testimony is also evidence. So we talked about a lot. That was a long chapter. I think that's the longest lecture I've posted in this class, because it was pretty. It was a lot. We went through the whole trial process all the way to the end, where a person's either acquitted by the jury after deliberations, or they're convicted. And then when they're convicted, that's when we move to chapter 14, when we talk about post conviction, when a person's sentenced and what their appeals rights are. We talked about the types of punishment and the types of sentences, whether it be determinate, indeterminate, or capital punishment. We talked about probation and all that stuff in chapter 14. From there, we moved to the final chapter, the chapter on counterterrorism. And I told you the reason counterterrorism is included in criminal procedure is there are a lot of through terrorism and the fear of terrorism. A lot of laws were made out of fear, or we as citizens kind of turned a blind eye to the fact that we were giving the government the ability to place us under like almost 24-hour surveillance. Like pretty much whatever we're doing is being watched or being listened to. We talked about the laws that applied to that, and the fact that people were being detained overseas as enemy combatants in their countries and being brought over to America and tried in American courts for something that essentially happened during a war. Um, some people were detained and initially they didn't have counsel or right to counsel, and how after lawsuits that stuff changed. So that's what we talked about in the last chapter. So that's pretty much everything we covered over the semester. So I hope you learned something. I hope take something away from this class. I hope it helps you become a criminal justice professional in whatever capacity you want to do that. Some of you guys want to go law school. Some of you guys want to be in law enforcement. And there's a lot of stuff you can do with a criminal justice degree. Some of you may want to, further your education outside of law school, go to get a master's, get a doctorate, and maybe teach like me. But just be good at it, at whatever you do, and hopefully you'll gain a career out of this. And hopefully I've helped you and taught you, and maybe giving you some knowledge you didn't have, or some knowledge that would help you go into the world prepared to fight the system and beat the system and be the best you can in the system. So that is it for the semester at this point from the book. So there are a couple more things you'll see announcements. So to let you know when stuff is due and stuff will be posted. So in general, I like to give announcements at the beginning of the week to let you know kind of what we're going to be doing this week. But you guys take care.